Hello, everybody, and welcome to this edition of the Family Matters podcast. Please remember that Family Matters is not a legal service and we provide no legal representation. No information shared with you today for our podcast could be considered legal advice or representation. Family Matters operates under a grant from the U.S. Department of Education, but no information we share should be misconstrued as opinions or information from the U.S. Department of Education. So we started launching a podcast in the beginning of 2024, and we're very excited that we've reached so many people, and people are able to listen to our podcast on multiple different platforms. And we love when other outside agencies get to join us, and that's what's happening today. So Ms. Laura Hart from IGAC, or the Illinois Guardianship and Advocacy Commission, is here today to talk to us about prior written notice. So Laura, if you wouldn't mind giving us an overview of what is IGAC.
Sure. So the Illinois Guardianship and Advocacy Commission is broken down into three divisions. We have the Office of State Guardian, and that is the division of the agency that does exactly what it says. They're state guardians of last resort. So when an adult, needs a guardian and they do not have anyone available to fill that role, then a court appoints the Office of State Guardian to help those people navigate through guardianship. We also have legal advocacy services. So they provide legal support to individuals with disability. A lot of their role falls into the mental health community, helping with involuntary commitments and helping support individuals in that capacity. And then we also have our Human Rights Authority, which is our investigative body, and they get complaints of rights violations, individuals with disabilities, and potential law violations. They're run by a board of volunteers from the community in which they serve, and they decide whether they have enough information to go out and investigate. They help conduct the investigations, and then they write reports. And the goal for the Human Rights Authority is always systemic change. So they're looking for keeping those cases open, working with the disability service provider, and trying to help change policies, procedures, help them align with the law in any way that they can, so that we're not just helping the individual that the complaint was made on behalf of, but also future individuals down the road through that systemic change. So several years ago, we were getting an influx of special education cases, and it became very evident very quickly that the HRA process that is wonderful and designed, again, for systemic change was lengthy, and it was not going to be fast enough to help support parents and students with disabilities, because in the life of a child, a 6-month investigation is half a school year. And so they need additional support in a different way. So we were able to work with the legal advocacy services and human rights authority and create a collaboration that we call our special education division. And we provide services in three areas. So the first area is education and training, information resource. Basically, that's just helping families understand the special education process. They call us with questions. They say, my student just got an IEP and I don't know what that means, or they're asking to evaluate, what do I do? I'm panicked. And we provide them with resources. Very often we're sending them to the resources that Family Matters offers. We do have a training posted on our website that is a 4-hour special education overview. It's divided up into 4 sections so that people can watch the whole thing, or they can come watch a section that they need at that moment, or come back and review it quite easily. And so we always suggest people start there with just a general overview. And then if they need more specialized, training, if there's an area such as prior written notice that we're talking about today, that they need more assistance, to let us know, and we will, get them to the right person or help answer their questions. So that's the first area. That's a good chunk of what I do in my day, is just help answer questions so that other people can be advocates. The second area is formal advocacy. So in those cases, individuals need additional support, and they need someone to help walk them through the process in a more formalized way. So it can also include training, but for the most part, the people that are asking for an advocate are individuals who are looking for someone to help them prepare for IEP meetings, review the paperwork, review the evaluations, help them understand what they mean. We can attend IEP meetings if that's what the family thinks would be helpful to them. We cannot attend. We can just prepare and then debrief afterwards if that's what's needed. It's basically designed to help support families with procedure and law. So we're not going in, we're not representing anyone, but we are empowering and helping families know what they need to know. And sometimes that means that I'm sitting in the background during a meeting to help clarify any questions or help, them understand the process that way. I tell parents to tag me in. That's like become my line. So I'm there if they need me. And then if something comes up, they don't understand, or they're frustrated, or they don't know what to do when things aren't moving the way they want, then they just say, "Hey, Laura, what can I do here? Or what are my options? Or do you have anything to say about that?" And provide support that way. So we have several advocates now across the state. We're able to provide that advocacy services to everywhere in the state. We attend meetings virtually at this time. That helps us support more people. And we have found that that's very the simple process, but it has a very big impact. Our third area that we offer special education services in is legal guidance and resources. And so there is a point in time in the process where a parent has utilized procedural safeguards. We've collected all the data, we've had all the meetings, and the parent is left with the option of mediation and due process. And for those processes, we want to have an attorney involved. We know that cases that have attorneys involved are over 70% more likely to be successful in mediation and due process. So we were able, as part of our collaboration with Legal Advocacy Services, to get a paralegal and attorney on board to help parents navigate that process as well, if they get to that point. So again, we offer services anywhere in the state. Our services are free of charge. We do have like a side note to that. If you get to a legal advocacy point where you're doing mediation or due process, there could be some potential fees involved in that. And so that will be between you and the paralegal to talk about what your contract looks like and what you need. It's very case by case. We don't see it very often, but we just want people to know that that's a possibility. But otherwise, we take intakes, we answer questions. You can reach us through our intake line on our website, or you can reach out to me personally through my email. So whatever is easiest, and we'll help you figure out which of the three areas you need and help you figure out, the intake process for us if you need a more formalized service so that parents can be better advocates for their student.
And if you're listening to this just audibly, you can find IGAC's information on the Family Matters website. There will be a link to their website on this podcast in the description. And we also share a lot of their information as far as, the 4-part training series. There's a link on our website to take you there as well. So I am displaying that on the screen if you're watching this, but if you're listening to this, I'm going to check that out later. You can absolutely reference that. So I asked Laura here today to talk about a topic that I feel I could be more educated on, and that is PWN, or prior written notice. So there's always a lot of questions regarding, it's a very small section of procedural safeguards that talks about prior written notice, but I feel like it's a very powerful section for a parent to understand their rights when it comes to special education. So I'm asked Laura here today to kind of explain prior written notice to us better. So that leads to my first question, Laura. What is prior written notice?
So prior written notice is basically exactly what it sounds like. It is the part of our law that says that the school district will not make any changes to an IEP without written notice that meets very specific criteria. And those are the criteria you have pulled up on the screen. They're part of the procedural safeguards. Basically says that they have to provide it notice anytime that they are agreeing to or disagreeing to making a change. And so we want them to provide that anytime there's a change, anytime a parent makes a request, anytime the school district decides that they want to increase minutes, decrease minutes, change a service. We want them to put all of those pieces together in notice so that the parents have that and can understand that and review that.
And I think that answered the question, what's the purpose? And it's so you can review it and prepare for your upcoming meeting with the school district, correct?
Yes.
Okay, perfect. And can you give me some examples of what prior written notice might be for? I know we just talked about it a minute ago, but could you give me some more examples, like what kind of services they may be adding or wanting to take away?
So the most common things are that we see parents wanting prior written notice for are related services. So things like occupational therapy or speech therapy, where there's a disagreement about how much or how little a student will receive. And that can go in both ways. Sometimes the district thinks the student needs to have more speech services, and the parent says, no, we don't want them pulled out of class that much. Sometimes the parent is saying we're seeing these, problems, and the district is saying we're not seeing them at home. And what we want in those circumstances is we want them to say, hey, this is the rationale behind why this decision is made. It's not just we don't think or we don't feel. It's that this is what the data says, and this is what we're going to do or not do, and this is why. And it really requires them to put all those things together for any request, really. But I think most commonly we see that for things like placement changes or related services.
Okay. So what does prior written notice look like? I mean, what does it look like when I get it? What should I watch for?
So here's the complicated part in the state of Illinois, in my opinion. So IDEA is the federal law that outlines prior written notice. And the way the laws work, a federal law has to be followed, but it can be interpretable to some degree. And so in Illinois, we allow the final copy of the IEP to be prior written notice. And so that sometimes can be very confusing. So the school district will tell a parent, well, we already gave you prior written notice. And what we recommend, if someone calls us and they say, hey, the district is telling me they gave me prior written notice, but I didn't get it, go back to the IEP, take it against that list that you're seeing there. These are all the pieces that are supposed to be in that prior written notice. And I tell parents, I'm like, go highlight each of those things. So what is there a denial? Yes. Is there data? Is there a rationale? Are my safeguards explained to me? All of those things need to be in the IEP for it to count as prior written notice. Or it could be a letter. We see that far less frequently is a situation where we have communications that specifically go through and bullet point those. When we have an advocate involved, or when we have some confusion at the end of a meeting about what's going to be done or not done, we can ask for that. But again, a lot of districts are going to default back to that final IEP draft, not the draft, but the actual copy of the IEP at the end of the meeting, with like all the additional notes, and talks about the discussion that was had, and it talks about what was decided, but also what was considered. So did we consider, maybe increasing a little bit, or did we consider taking a student out of one class and putting them into another? And the additional notes typically cover a lot of that discussion. If it doesn't, if the IEP doesn't have all those components, then we encourage parents to email the district and say, this does not meet all the criteria of prior written notice. And so we would like you to please formalize that into a letter so that it can be clear for us to understand.
And I think that's what's the huge confusing part is the prior. So to me, looking at before stepping into the role with Family Matters, I thought I would get, along with my notice of conference, it would state in there, we intend to change your child's placement, or we intend to add a service. But now, after being in this role, that's almost predetermining. So I can see why the prior part gets a little confusing. But if you look at it with really focus on our timelines, an IEP takes 10 days to go into effect after the meeting, unless you sign a document stating you want it to go into effect immediately. So then that is prior to your IEP going into effect. This is serving as your prior written notice. So that's kind of the way I understood it. Is that correct, Laura?
Yeah. So they're giving you 10 days notice. Now, you might waive that.
Mm-hmm.
So, keep that in mind, but it's not prior to a meeting, it's prior to the change. And so at a meeting, a change is discussed, and that meeting is your 10 days notice. So they're giving you that final copy, which again, I have seen states that do phenomenal prior written notice. They have like cover pages that check all the boxes,
I've
but
seen
that's
that.
not
Yes. Yeah.
that's not what we do here. And
Yes.
so you do have to kind of dig a little bit here in Illinois. But then it's prior to that 10-day implementation, not prior to the meeting. So yeah, you're right.
Sometimes these things are mentioned in the draft IEP, but they may look a little different. Like it might be evaluation results, which not all of us understand how to, pick apart and understand evaluation results. And it may be a note from an OT stating, Johnny's met his goals phenomenally this year, and I think we might need to reduce services. So it can be a part of your draft IEP, not necessarily serving as your prior written notice, but there may be mentions of it in there. So that's why we always encourage a record review when you receive that draft copy. And we get 3 days to do that. Sometimes that's not a lot, especially for Carrie and I or Laura, that when it's IEP season and you're getting 100 reviews to do a day. But it does, if you read through that, sometimes that can help you be prepared for the meeting. I guess I could say it that way.
It does definitely help a parent to not feel so blindsided.
Mm-hmm.
So I think the law was designed to really protect us from entering into those meetings without having a clue what they're going to talk about. What I think happens sometimes is a school district believes that that information is included in there because they do know what it means. They do know how
Mm-hmm.
to read the data. They do know those things. And so they think it's clear. But as a parent who is emotionally invested and, just sometimes looking at those, 40 pages as being, seriously overwhelming, it's a lot harder to interpret like what the intent is.
Mm-hmm.
But that's the goal. Like we should get that 3-day draft so that we can read through that and we can say, okay, this is going to be, this should be a pretty par for the course IEP meeting, or we can look at it and say, wow, this student is really struggling. So I anticipate some big changes, and we can get a rough idea before we go in there of what kinds of things we're going to be discussing.
Sure. And I as a parent, I have 3 children that have an IEP currently, and one of them just graduated. Yeah, last few weeks ago. Um,
Congratulations.
Yeah, thank you. I like to follow up every meeting with an email, even when I have that final copy, which I never leave a meeting without that final copy of an IEP. If it's a virtual meeting, I like to have it within, an hour after the meeting because your 10-day timeline starts ticking after your meeting to really go through and review things. But I like to follow up any verbal communication with the district, including IEP meetings, with an email and just kind of restate what I heard. And if I think the district has provided me with prior written notice, I'll restate that in there. If I think they have not, then I ask the question, does this serve as my prior written notice?
Very good.
Yeah.
Gives you that paper trail and make sure that everything is clear.
So I skipped over this question and I'm sorry, but does prior written notice and denial in writing, are they the same thing? We hear those phrases
Yes.
both a lot. Okay. All
Yes.
right.
Prior written notice, technically. So when I am talking to parents and I say, did we get prior written notice? I'm looking for anything that's in writing that has all those components. If we didn't get anything in writing that has all those pieces to it, then that's when we're sending an email asking for them. But really, anything, they're the same. Any denial, but it could also be, something we agreed upon. It's not always used just when they're denying things.
Okay. All right. And when I do the ESP training for new ESPs, we talk very briefly about prior written notice. Now I'm going to have this podcast I can share with them, which is great. And we also highlight, the denial in writing. You've asked the district for a request, and
Mm-hmm.
that if they deny that request, that needs to be done with justification. And we need to talk about other alternatives you could consider. And that should be stated in your notes to the IEP. There's times as a parent or an ESP, I will ask that be restated. Can you make sure in the notes that I asked for such and such? Instead, the district suggested this, and this was the justification. I mean, I absolutely understand that's a human being taking my notes, so it's not going to be word for word. I talk fast when I get excited, I guess I could say. So that is, it's not going to be word for word, but I love to just send an email to the district after a meeting and restate what I felt I heard in the meeting.
Absolutely. Well, and it assures that things in text can be misconstrued.
Mm-hmm.
And there's just no way around that. I mean, if read through the information after the meeting, especially, and you say, that doesn't really sound like what I said. It's what they heard, but it
Mm-hmm.
might not be your intent. So you want to make sure too, if anything that's in that afterwards is unclear or it reads differently. I tell parents all the time, like, have someone else read the additional notes section and
Absolutely.
see
Yeah.
how they interpret that, especially because, again, like as a parent of a student with an IEP, you're emotionally invested in this. And so we can get kind of fired up or even kind of weepy about like the
Mm-hmm.
good things, and we miss the interpretability of that. And so we want to make sure that what we see is what we intended for it to be. That way there's no confusion going forward.
Absolutely. There's been times I've left IEP meetings when I'm just so upset with the entire situation, and I will bring the paperwork home to my husband or my mom, and they'll read through it, and they're like, "This looks like this was a good meeting," and I'm like, "What? How can you think this is a good meeting?" And talk about what the notes said, and we go back over it. But there is a lot of emotions attached. We always here at Family Matters let the parent know, look at it as a round table. Everybody's on the same side, and that's the side of the student succeeding in their environment, in their educational setting. So, we try our best, but I think prior written notice, I really like that you cleared up that it doesn't necessarily have to come to you in a letter before. I've seen them like that. Those are really nice, but it doesn't necessarily have to. That it serves as your notice before your IEP goes into effect at the 10-day mark. So, following up on that, should I choose to sign that my IEP go into effect immediately, does that take away anything to do with my prior written notice? Like if I was not agreeing with something?
No.
No.
So anything you consent to can be unconsented to. So waiving that 10 days notice doesn't mean that you can't say, hey, I still want prior written notice of that. Those things are not, one doesn't trump the other.
Okay. Awesome. So if I want to understand more information about prior written notice or need more resources or want to refer to something when I'm speaking to my child's district, where can I find that information?
So when I'm working with parents and we're talking about prior written notice, I tell them two very simple things about where to get information on prior written notice. And you're going to laugh. So the first thing I tell people is if you get on and you Google or search on your search engine, prior written notice ISB, you're going to get the procedural safeguard documents. Now, every single parent at the beginning of every meeting is offered a copy or should be offered a copy of their procedural safeguards, and it's very clearly put into that. But
I think it's on page 1. Yeah.
yeah, we frequently kind of gloss over that and panic.
Mhm.
Or if we got a copy 6 years ago and we're just saying, yeah, we have it, you can find it very easily by just searching it. The
Mhm.
second place I tell people to go is actually Family Matters, because you guys have some really good handouts that we reference a lot when we're talking to parents that break down all the components of prior written notice. Does it have it? There's some good examples of prior written notice. And so we send them to you for those examples, for using your website.
Well, thank you. That makes me feel very proud. We've worked really hard to share those resources. So, and
Absolutely.
we're
No need to
yeah.
reinvent the wheel when yours are
Yeah,
so good.
well, thank you. Thank you so much. But at the same time, I really felt like it would be great to sit down and talk with someone about, help us understand what prior written notice is. And I feel like even I understand it a little bit better after doing this podcast. So we can't thank
Yeah.
you enough
Oh,
for
thanks
for
for having
joining
me. It
us
can be really
today.
confusing and stressful, and it's not always the words we would use, it's the words the law uses. And so
Mhm.
if, there's any questions after this, please feel free to reach out. I'd be happy to help people find the answers they need.
Absolutely, and that's the big thing. And as it's summertime, I think the last district in Illinois, this is the last week of school for them, if I read that correctly, or maybe I talked with Laura about it earlier. I can't remember, but so it's getting to the time where people are going to be like sighing with relief just a little bit about IEPs. So this is a great tool to have. So when you come back in the fall, you understand what PWN or what prior written notice is, and maybe that can help you prepare for your upcoming meetings next year.
Awesome.
Yes. All right. Thank you so much for joining us today, Laura.
Thank you.